Hello friends, this is Y. Radheshyam, Assistant Personnel Officer, currently working in Western Railway at Sabarmati Engineering Workshop. Today I am going to give lecture on DR rules as you can see on my screen. Many my students from South India and other part of India, they are repeatedly requesting me to make a video in English language. So this time I am going to try that lecture entirely in English so that they can be benefited from my videos, my lectures. So I'm going to start first as I in Hindi I also tried my first video in DR subject. So I am starting this video in English, entirely in English. So first I have stated that this is a DR rules 1968. I will discuss on the subject application appointing authority under DR rule, disciplinary authority, suspension, penalties, various penalties under rules 6, procedure for minor penalty cases and procedure for major penalty case I will not discuss due to shortage of time. That will discuss after some time. What is substitution allowance and revision review under DR rule. Now I am going to start the Railway Servant Disciplinary Appeal Rule 1968. As per DR rule, Rule 1, these rule may be called Railway Servant DR Rule 1968 and these rule are came into force from 1st October 1968. Earlier, there was a DR rule that is applicable from 1st August 1961. Now that has been cancelled by Railway Board and new DR rule has been implemented with effect from 1st October 1968. So there must be a question in in DR rules that from which date DR 1960 has been implemented in railways. So you can give answer 1st October 1968. The next thing is applicable or application of DR rule in on railway employees. So as per Rule 3, these rules are applicable to every railway person except following, that is all members of All India Services, staff of RPF, Railway Protection Force. There is separate rule for RPF staff and the person who are working in railways as a casual employment. So these are the person whom their rules are not applicable. Otherwise, every railway employee is governed under DR Rule 1968. Now, next point is appointing authority as per Rule 2 of DR Rule, that is definitions. The first definition is appointing authority, and I would like to state that we must know about appointing authority under DR. Everyone think about what is the necessity of knowing appointing authority. Then I will like to tell you that there is a most important role of the word appointing authority because everyone knows that as per Rule 6, there are certain penalties mentioned in Rule 6, 1 to 9. There is 4 minor penalties and 5 major penalties. So then penalty number 7 to 9. 7 is compulsory retirement, 8 is removal for service, and 9 is dismissal for service. These 3 penalties can be imposed on any employee by only appointing authority. So we have to know about the appointing authority for every railway employee, who is the appointing authority for particular that employee, so that we can impose 3 penalties like 7, number 7, number 8, number 9. So it is very important term appointing authority. I can tell you who is the appointing authority. Railway Board has prescribed as per SOP 2008 for level 1 employee working level 1 appointing authority junior scale, level 2 to 5 senior scale officer of the appointing authority, and level 6 and above J grade officer of the appointing authority. And in special cases in artisan category, employee working level 2, in that case also junior scale officer are the appointing authority. So this should be kept in our mind while dealing DR cases. Otherwise, there will be wrong thing happen in while dealing the DR cases. So as per the definition, of appointing authority, it is said that who can appoint person to service or post or to the grade of service. Means appointing authority is the person. This is the authority who can appoint a person to particular post or grade on which employee is currently or presently working on that post. So suppose a person is working in level 5. The appointing authority must that this is the competent authority to post a person on level 5. Then he will be the appointing authority, and as per SOP to the 18, for level 5, senior skill officer is the competent authority to appoint any person on that post. So we have to see who is the appointing authority or for particular post. And another thing is who appointed the railway surveying to such service grade and post, whichever is higher. There is a possibility that an employee is joined railway in level 1, then in this case junior scale officer is the appointing authority for that particular employee. Then, but subsequently, if the employee promoted from level 1 to level 3, level 4, and then he reached to level 6, in that case, J grade officer will be the appointing authority. So we have to see the current post of the employee, not the post on which he employee was appointed. So whichever who is the higher authority, he will be the appointing authority. There may be cases that a person who is appointed on level 1, he subsequently promoted to level 6, then due to some DR cases or any reason, he was again reverted to level 5, level 2, level 3, due to surplus medical education, any of reason, then if he is again reverted to level 2, then level 2, then senior school officer will be the appointing authority. So we have to see the current post of the employee for deciding the appointing authority for that particular employee. There may be cases when we cannot found the actual appointing authority or the particular employee due to the non-availability of the record in his service books. So in that case, as per the policy, GM will be the appointing authority of that particular employee. Now the terms come disciplinary authority. There is a difference between appointing authority and disciplinary authority. Appointing authority for one person will be the one person, but there may be two disciplinary authority for particular employee. How it is calculated, I will tell you. The disciplinary authority means the authority who can issue charge sheet. There is a difference between appointing authority and disciplinary authority. Disciplinary authority related with the issuing of charge sheet for non-gazetted staff in relation to Rule 11, one who can impose any of the penalty in Rule 6 of DR, and in relation to Rule 9, one who can impose any of the major penalty of Rule 6 of DR. Means a person, an authority who can impose any of minor penalty to any employee, then he can be a disciplinary authority for issuing minor penalty charges, but there is a possibility that he cannot impose major penalty due to he cannot issue a major penalty, impose a major penalty on the employee. So then there may be two disciplinary authority for particular person. If authority can impose any one of the minor penalty, then he can be the issue minor penalty charge sheet. If an authority who can issue major penalty charge sheet, if he can impose any of the major penalty specified in Rule 6. So there may be a difference between appointing authority and disciplinary authority. There must be only one appointing authority for particular employee, but there may be two disciplinary authority as far as employee working in lower side, means if level 1 to level 5. Otherwise, for level 6 and 7 above, J grade will be the disciplinary authority for issuing minor penalty charge sheet and the major penalty charge sheet. But for lower level employees like level 1, level 2, level 3, there may be separate disciplinary authority for issuing minor penalty and major penalty. And but as far as gazetted officer is concerned, there is a different rule for gazetted officer. There is a provision for gazetted officer that if any authority who can impose any of minor penalty under Rule 6, then he can be a disciplinary authority for both minor penalty charge sheet and major penalty charge sheet. He can issue major penalty charge sheet to a gazetted officer if he can impose any of minor penalty to him. But if after issuing major penalty and after completion of DR inquiry and DR procedure, if he think that he wants to impose major penalty, then he may refer his case to the competent authority who can impose a major penalty on concerned gazetted officer. So there is a difference between disciplinary as far as Group C staff is concerned and as far as gazetted officer is concerned. Another definition is suspension under Rule 5. It is specified in Schedule 1, 2, 3 of DR rules. Any authority may suspend. Suspension can be done any subordinate officer, railway servant who is not controller shall report to concerned authority who is the competent authority to suspend. This means there is a specified authority under Schedule 1 to 3 who can suspend a railway servant, but there is a provision in their rule that a lower authority can suspend an official junior to him, but if he is not competent to suspend, then he should report the competent authority within 24 hours and take the approval from the competent authority. And another rule regarding suspension is an order of suspension made shall not be valid after a period of 90 days unless it is extended after review for a period before expiry of 90 days. Means any order regarding suspension, it is valid up to 90 days. Otherwise, it is extended by the competent authority. Means an order of suspension is valid only up to 90 days. If any employee, if we want to continue an employee beyond 90 days, then we have to extend the 90 days period by reviewing the DR cases and then take approval from the higher authority who has approved the suspension. The on review period of suspension can be extended for next 20 days at a stage. Means first the suspension will be for 90 days and thereafter every subsequent suspension which is extended by the review, that will be 180 days at a stage. And review will be done by the 3 officers who 2 are the equal of the officer suspended him, and then approval will be taken from the next authority who has suspended the employee. The schedule for DR, there is a Schedule 1, Schedule 2, Schedule 3 under DR rules. Schedule 1 is applicable to Railway Board, RDSO, IRISET, Secunderabad, Nair, IRISEN, IR, MEE, RRB, RRT, and all other offices not shown above. And Schedule T, mostly we are working in maximum railway employees are working in zonal railways, then which comes under Schedule 2. The Schedule 2 cover up zonal railway, Chittaranjan locomotive works, diesel locomotive works, integral coach factory, railway factory, metro railway, diesel modernization workshop, rail coach factory, railway electrification project, metropolitan transport project, and Schedule 3 is for gazetted employee Group A and Group B. So there may be a question that which schedule deals with the gazetted officer, their rules deal with the, then we can say the Schedule 3. There is clerical typing mistake in 3. Here it should be Schedule 3. Please correct it. Authority as per schedule, senior subordinate in charge Group 42 and above. I can show you directly to SOP. This is SOP Schedule 1. And as maximum employees are from zonal railway, so I would like to discuss on the directly Schedule 2. So this is Schedule 2. Schedule powers and powers of suspension difference grade of railway employees, railway officers, and senior supervisors in respect of non-gazetted staff of zonal railway. So, though maximum employees are working zonal railway, so I would like to discuss on Schedule 2. As per the Schedule 2, senior supervisor in charge with grade pay 42 and above, class of railway servant over whom disciplinary powers can be exercised. Nature of penalties mentioned in Rule 6, which the authority in column 2 is empowered to impose railway servant mentioned in corresponding entries in column 3, and power that authority to place under suspension. Both the authority for imposing penalty in column number 1, senior supervisor and above, can impose penalties as well as suspension, but suspension is subject to report to divisional officer within 24 hours. Staff who are working 3 grades below and lower than the disciplinary authority The senior supervisor will be the disciplinary authority for those staff who are 3 grade below, and they can impose the penalty specified in Rule 6 of 1 to 4, all 4 hours minor penalty just sheet. And the next appeal authority will be junior scale officer as per SOP. Junior scale officer, Group B junior scale officer, State, they will be the disciplinary authority for staff working in grade pay 2400, means level 3. They can issue penalties specified in Rule 6, that is 1 to 5. Here I would like to say that if any minor penalty can be imposed by any authority, then he can issue minor penalty charge sheet, and he can impose any of one of the major penalty charge sheet, then he can issue major penalty charge sheet. In this case, you can see assistant school officer can impose penalty number 5. This is a major penalty. So he can issue SF5 to staff working in level 1 to level 3. In senior school officer will be the appeal authority. For senior school officer, they will be the disciplinary authority for staff working up to level 20, GP 28, means level 5, and they can impose penalty 1 to 6. So they can issue major penalty charge sheet. By going through this SOP, you can see that Group C staff, supervisory staff cannot issue major penalty charge sheet to any employee working under them, even they are 3 grade below, because they can impose only 1 to 4 minor penalty charge sheet. So as per the rule, DR rule, for issuing major penalty charge sheet, authority must have the authority to impose any of major penalty, one of major penalty. So supervisory staff doesn't have the power, authority to impose major penalty, so they can't issue major penalty charge sheet. They can suspend the staff and can report to divisional authority, but they cannot issue major penalty charge sheet. Major penalty, the minimum authority under DR rule for issuing major penalty charge sheet is assistant scale officer. So this is SOP, and same SOP for JG grade. There are disciplinary authority for all gazetted staff, and they can impose any of penalty number 1 to 6, and I have already stated that penalty number 7, 8, and 9 can only be imposed by the appointing authority. Here we can see then appointing authority on authority of equivalent rank and any higher authority shall be competent to impose penalty specified in 7, 8, and 9. So the only appointing authority can impose penalty number 7, 8, 9, that is compulsory retirement, removal, and dismissal. So now coming back to our PPT, this is I have stated. Then next issue is suspension. What is suspension? A railway employee may be placed under suspension. There may be certain circumstances under which a railway employee can be suspended. The reason for suspension circumstances are: a disciplinary proceeding is contemplated or pending. There may be a reason the disciplinary authority wants to place the railway employee suspended, that he wants to initiate any department action against an employee due to certain breach, heavy misconduct done by the employee. And second is, employee is engaged in activities prejudicial to the interest of security of state. And third is, any criminal offense is under investigation, inquiry is on trial. There may be reason that employee is involved in any criminal activities, and there may be any report received from the police or any other authority regarding the involvement of the employee in criminal activities, and on that basis, disciplinary authority can make an employee under suspension. There is another thing, deemed suspension. A railway servant shall be placed under deemed suspension. I would like to state one thing, that suspension is always from prospective date with immediate effect. That will not be from the back date or retrospective effect, but the deemed suspension is always from the back date, means retrospective effect. And deemed suspension, the circumstances under which a railway employee is placed under deemed suspension are: if a railway servant is detained in custody for a period exceeding 48 hours, if any employee, due to any reason, if he is detained under custody and he remain in custody for more than 48 hours, then he will be placed under suspension. There may be possibility that he doesn't have any, he is innocent person, but somehow reason he was detained in custody, then as per this rule, employee must be kept in deep suspension. And other thing is conviction sentenced to a term of imprisonment exceeding 40 hours. If any employee, railway employee, if he is convicted by the court of law or sentenced to a term of imprisonment exceeding 40 hours, then if as per rule 14, I will tell you later on that as per rule 14, he must be impose any penalty without going to issue any charge sheet and inquiry. He can state, disciplinary authority can straight impose any of penalty under rule 6, but there may be reason that we received some late information about his detention, his conviction, and if we received the intimation regarding conviction later on, subsequent, and if we could not take any action immediately because there may be reason, there may be delayed as per rule 14. If any information received from any court of law, any from any sources that employee is convicted, then first we have to take the issue, deal the issue under Rule 41, then first we have to issue show cause notice to him, and on receipt of the reply from the show cause notice, we can impose any of the penalty. For it will take some time. So, if as per rule, if we cannot immediately remove from the service, then we have to kept him under deemed suspension. The penalty specified under Rule 6 under DRR. First penalty is minor penalties. There are 4 minor penalties. What are minor penalties? First is censure. Second is withholding of promotion for a specified period. Here, what I would like to say that any penalty imposed under Rule 6 that must be for a specified period. If period is not specified, that is not correct penalty. And if any authority, disciplinary authority has issued any penalty, he has not done any penalty. If he is not specified the period, then we have to send back the case to disciplinary authority for asking him to specify the penalty, specified time. So, number 2 is withholding of promotion for a specified period. Rule 3. Penalty number 3 is recovery of any pecuniary losses caused to the government or relevant administration. The recovery can be done from a railway servant if he has caused a pecuniary loss to railway administration. We can recover such amount either partially or fully amount. And 3A, penalty number 3A, withholding of privilege passes or PTO and both. The withholding of passes PTO is third A penalty, 3A penalty. 3B is reduction to a low stage in timescale pay by one stage for a period not exceeding 3 years without cumulative effect, without future effect, and not adversely affecting the pension. There are 2 penalties. First, one is 3B and another is 5. There is difference between both penalties. 3B states only reduction by one stage and not for more than 3 years and not adversely affecting the pension benefit. Means if any penalty which is by one stage or up to 3 years and not with future effect, then it will be 3B. And if any penalty other than this, means any penalty, if any person is imposed penalty of reduction by 2 stage, 3 stage, means more than one stage, then it will be major penalty, which is comes at number 5. So any penalty of reduction, if it is more than 3 years, that is major penalty. If any penalty is given for even one stage for 2 years, but it is with future effect, then it is also a major penalty. So the penalty comes under 3B will be only for penalty of reduction by one stage for 3 years and without future effect. It will be treated as 3B and minor penalty. If it is for with future effect or more than 3 years or more than one stage, then it will be major penalty. I will discuss later on penalty number 5, but it is 3B. Penalty number 4, minor penalty 4 is withholding of increment of pay for a specified period with or without future effect. Then I would like to state the withholding of increment penalty. Sometimes many of employees became confused regarding the tenure of the withholding of increment, as per this rule 4, rule 6, it is withholding of increment for a specified period means any authority, a disciplinary authority can impose relevant this penalty, that is withholding on payment for a specified means 1 year, 2 year, 3 year, 4 year, any number of years, but that must be for, as per this rule, maximum 3 years penalty can be imposed for a employee. And if you any disciplinary wants to impose more than 3 years penalty, 3 years stoppage of increment, like 5 years, 10 years, he can impose, and it will be a minor penalty. But as per Rule 11, if any disciplinary want to impose more than 3 years or having with future effect penalty, then it will be, he has to, the inquiry is mandatory under Rule 9. So, if you state will impose any penalty of withholding of increment without any inquiry, then disciplinary can impose only the penalty of withholding of increment up to 3 years, and that must be without future effect. If that has the effect of with future effect penalty or more than 3 years, then inquiry is must under Rule 9. Likewise, in major penalty. Now we are coming to major penalties. There are 4 minor penalties which I've just completed. Now come to the major penalties. First major penalty or serial number 5 penalty is save as provided in class 3B above, reduction to low stage in time scale of pay for a specified period with or without future period. Means penalty other than other penalties which is mentioned, other than the penalty as mentioned in 3B, that leaving that penalty and other penalty, like I have already stated that in 3B there will be a reduction of 1 stage, but if more than 1 stage, then it will be in it is stated that it is 5 number penalty. Otherwise, it will be 3B. So there is a difference between 3B penalty and 3B and 5. If any reduction is up to 1 stage and up to 3 years, then it will be 3B minor penalty. And if it is more than 1 stage or more than 1 stage but more than 5 years, sorry, 3 years, or the penalty of 1 stage having the effect of with future, then it will also be a major penalty. So there is a slight difference between 3B and 5. I think you can better understand this. Now, penalty number 6 means reduction to low time scale of pay, grade, post, and service for a period to be specified in the order of penalty, which shall be a bar to promotion of the railway servant during such specific penalty, the time scale of pay, grade, post, service from which he was reduced with the direction as to whether or not on promotion on expiry of such specific period, the period of reduction to time scale of pay, grade, post shall operate to future postpone future increment of his pay, and if so, to what extent. The railway servant shall regain his original seniority in the higher time scale of pay, grade, post. Straightway, if I would like to say this penalty means any person, if his penalty is in the same time scale pay, then it will be penalty number 5. If a person is working in level 6 or 7 and he is reduced, he is downgraded the post, downgraded to the post to level 5, level 4, then it will be 6 number penalty. And as per this policy, during the imposition of penalty, there will be a bar on his promotion during the currency of penalty, and disciplinary authority has to specify 2 things: whether the penalty has the effect of which postpone of the future increment, means whether it is a with future effect penalty or without future penalty, and on completion of the penalty, what will the seniority of the employee? That means whether he will lose the seniority or he will not the seniority. Both issue has to be mentioned by the disciplinary authority in his picking order. So this is number 6 penalty. We come to, I think another slide is missing. I will like to just tell you. Number 7 penalty is reduction, sorry, compulsory retirement. Number 8 penalty is removal from service. And number 9 penalty is dismissal from service, and we shall be barred to future government job in any other organization. So these are total 9 penalties. I'm due to shortage of time, I'm not discussing about minor penalties, imposition of minor penalties and major penalty. I'm just skipping this. Now come to the appeal. As per Rule 18, appeal can be preferred by the employee on what circumstances an order against which appeal lies. It is mentioned in Rule 6. As per Rule 18, an order of suspension made or deemed to be have made been under Rule 5. There are What are the provisions under which an employee can make an appeal? There are certain orders for which no appeal can be made, and there are certain things which against which an employee can made an appeal. So there are three things under which employee can make an appeal. First is against the suspension order. Either suspension may be normal suspension or dispensation. And another is an order imposing of any penalty specified in Rule 6. Any order if on employee, if any order of imposition of penalty, if any authority like DA, AA, or RA, means discipline authority, appeal authority, revision authority, if any authority impose any of the penalty on the employee can make an appeal against the order of imposition of penalty either by DA or AA or RA. And last thing is an order enhancing the penalty imposed under Rule 6. There may be the cases then if a disciplinary authority imposed the penalty of stoppage of increment for 1 year by disciplinary authority, and on appeal, if appellate authority wants to enhance the penalty from 1 year to 2 years, then first of all he has to issue a show cause notice specifying that he is enhancing the penalty, and on representation received from the employee, if still appellate authority or revision authority wants to enhance the penalty, decide the penalty to enhance the penalty, then employee has the authority option that he can appeal on the enhanced penalty. And at the time of if appellate authority enhance the penalty, then he can make an appeal on the appellate authority's order. And after appellate authorities, he has another chance of revision. And if revision authority again enhance the penalty, then he has also another option to appeal on the revision authority. So there are some circumstances against which, if in any case revision authority enhance the penalty, any person can appeal against the order of revision authority. There are certain provisions under which an employee can appeal on the circumstances as mentioned in 3 cases. Appeal may be considered by the authority under Rule 9. The appellate authority is specified in Schedule 1-2 of DN rules. Appellate authority is higher to the DA, who is immediate higher to authority who has imposed the penalty in appeal or revision. Time limit for appeal. Under Rule 20, an applicant can submit an appeal within 45 days from the date of receipt of the order against which appeal has to be made. So there is a time limit for appeal, that is 45 days. On receipt of the NIP, employee can appeal within 45 days. A can entertain delay appeal if satisfied with the reason given by the applicant. Though there is a time limit of 45 days, but due to somehow reason, if employee could not make an appeal within a stipulated time, then he can ask delay condition, and appellate authority can entertain his delayed appeal if there are justified reason. When appeal is against suspension, appellate authority shall consider whether the order of suspension is justified or not and confirm or revoke the order. If any appeal is done against the suspension order, then in that case, appellate authority to take the decision whether the order of suspension is justified or not. If it is justified, then it is confirmed, or other. If he seems that it is not justified, then he may revoke the employee. When the appeal is against the penalty, the AA shall consider. If appeal is against the penalty imposed by either discipline authority or discipline authority, then or revision authority, it may be revision authority, then next appeal authority will decide whether proper procedure has been followed. It is a mandatory condition that if any appeal is preferred or revision is preferred by the employee, then first the authority, appeal authority or revision authority, he has to ensure that first of all, entire disciplinary rules, proper procedure and rules are followed in particular case, and whether orders of D are warranted by the evidence or record, whether the penalty or enhanced penalty imposed is adequate, inadequate, or severe and pass order. The appeal authority, it is also one of the duty of appeal authority that he should ensure that the penalty imposed by the disciplinary authority or appeal authority or revision authority that it is adequate or either inadequate or severe, and then accordingly he passed the order. And what orders he can pass, that is he can confirm the order, enhance the order, he can reduce the penalty and set aside the penalty. There are certain issues he can do anything, either confirm or enhance or reduce and setting aside the penalty. Or another thing we can do, that is remitting the case to authority which imposed or enhanced the penalty. If he seems that there is a procedural lapse in the disciplinary proceeding, then he can remit back the case to the authority and ask to rectify the whatever lacuna he find in the disciplinary proceedings. It cannot impose enhanced penalty without giving reasonable opportunity. It is, I have said in one, that he can enhance the penalty as per their rule. Any enhancing, if disciplinary authority, appellate authority, or revision authority, he wants to enhance the penalty, then it is the mandatory condition that reasonable opportunity is to be given to the charge official in the form of show cause notice. Rule 25 specify about the revision. There is channel in DR rule. First, after issue of NIP by the disciplinary authority, another next channel is appeal. Employee can make appeal within 45 days. And after appeal, if he still not agree with the orders of appeal authority, then he can go for the revision authority under Rule 25. There is another 45 days time for revision after receipt of order of the appeal authority. Who can be the revision authority in particular case of? First is Honorable President has got full power, revision authority, any case and at any time. An employee can make a revision petition to President without any time limit. Another is Railway Board GM got the full power. Railway Board and GM can also be a revision authority for particular employee, and there is also no time limit for GM and Railway Board. And after last, divisional authority, when no appeal was preferred in revision, can be done by the DRM only. If employee after disciplinary authority, if appeal is not preferred, then DRM can be the revision authority in particular case. Last, in other normal situation, the revisioning authority should not be below the deputy HOD. Means JI grade officer can be the JI grade officer, not below the JI grade. No one can be the revision authority below the JI grade officer. And what is the authority they may have? The revision authority can confirm, modify, set aside the order, or confirm, reduce, enhance, or set aside the penalty imposed and impose any penalty where no penalty has been imposed. Remit the case to authority which made the order or any authority directing such authority to make and such further inquiry as it may consider proper in the circumstances of the case. Pass an order as reviewing. Means revision authority have also almost same power which the appeal authority can do. He can confirm the penalty or modify the penalty or set aside the penalty. Set aside means drop the charges, and in another way he can confirm, reduce, enhance, satisfy. If he found any lacuna in procedure, then he can remit back the case to the concerned authority, and he can pass any order which he deems fit. And Rule 25 is review. There is also provision DR rule after completion of revision. That is where a new fact comes to the notice which is likely to affect the substantially the decision in the case the President of India may review the case White provision Rule 25A. This is a special and rare provision. It is usually not used in the DR in normal all cases. It is only used when there is a new fact come to the notice and which is likely to affect the entire case. And the facts are come to the knowledge which are not available at the time of running case of disciplinary authority inquiry cases, and it is just come and it will affect the entire case and result may be different. So in that case, if there is a circumstances, evidence, new fact come to the knowledge and there may be possibility of change of the entire case, then in that case, president can review the cases. Only those cases which have this quality, this new effect comes to the knowledge, then only review can be done by the president. There is a special provision for non-gazetted staff under Rule 24. If any Group C railway servant who has been dismissed, removed, and compensated, only if three penalties are imposed, that is, removal, dismissal, and compensation on Group C, and after appeal to the appellate authority, if appellate authority disposes of as a stand good, then he may prefer revision petition within 45 days to directly to general manager for revision of the penalty imposed on him. There is a special provision for Group C staff. Any Group C staff he wants to send to case to GM for revision purpose, then he can do. And in that case, GM on receipt of the revision petition by the general manager shall dispose of the application in accordance with the procedure laid down under Rule 25. Then in that case, if a case has been referred to GM for revision, the GM authority will deal the entire case as per Rule 25 as earlier stated and then pass the order accordingly. Provided further where a revision application has been disposed of by general manager under sub-rule, no further revision shall lie under Rule 25. Means if any employee, if he prefer revision petition to general manager and general manager accordingly dispose of his revision petition, then he will not get another chance for revision in normal case. That means a person can apply for revision either to general manager or to in routine way. There will be only one chance to railway employee. But there is a provision to any railway employee, then he can prefer a revision petition to general manager under Rule 24 of TRO 1968. Another rule which is also very important in their rule, which is Rule 14. There are many questions come in examination point of view. It is also important for examination point of view. 14.1, 14.2, 14.3. As I have already stated earlier, that in case of any criminal case, if any employee is convicted, then he can be imposed any of penalty mentioned in Rule 6 directly under Rule 14.1. What is Rule 14.1? I would like to state now. Where any penalty imposed on the railway servant on the ground of conduct which has led to his conviction on a criminal. If any employee is convicted in a criminal case by the court of law, then he may be issued directly show cause notice under Rule 14.1 and then disciplinary authority is free to impose any of penalty mentioned in Rule 6 as per Rule 14.1. And regarding 14.2, it is stated that where the disciplinary authority is satisfied for the reason to be recorded by in the writing, that it is not reasonably practicable to hold an inquiry in the manner provided in the rule. This means if disciplinary authority is satisfied, if he thinks that as per Rule 9, inquiry cannot be possible to conduct due to such circumstances, there may be reason that employee has joined the terrorist organization or there is a person for which employee is not practically possible as per Rule 9, then he will write the reasons for which inquiry is not possible. Then he can issue any penalty under Rule 6 directly without imposing major penalty and going through inquiry under Rule 9. And Rule 14.3 state that if President is satisfied that in the interest of security of state it is not possible to hold an inquiry in the manner provided. If similar likewise 14.2, there is another provision 43. In this case, if President is satisfied that as per extant rule, inquiry is not practicable, then he can also issue any penalty. This is called Rule 14.3. Provided that railway servant may be given an opportunity of making recommendation on the penalty proposed to be imposed before any order is made in case of falling under Class 1. While dealing the case under Rule 14.1, in that case, if employee is convicted by the court of law, first, as per this rule, first disciplinary authority has to issue show cause notice, giving circumstances why he wants to take action against him, and then he can impose any of the penalty under Rule 14.1. So I think time has completed. So I would like to state that please state about my today's lecture, how you feel about watching this video.